talking directly to the H1 sub, I find that the epicenter of this legislation in the substitute is Section 5, which states that a local unit of government shall not enact or enforce any law, ordinance, policy, or rule that limits or prohibits a peace officer or local elected official, officer, or employee from communicating or cooperating with appropriate federal officials concerning the immigration status of an individual in this state. You know, I guess the targets of my concern, among many, are that this legislation is written very broadly. And when you're talking about communicating and cooperating with from a local official, officer, employee to communicate and cooperate with federal officials, that's not defined in this statute. And so you are going to get people who are going to widely interpret this as an authority to police as immigration officials. So I want to just clarify, and maybe you can respond here. Nothing in this legislation says that the undocumented immigrant has to have been in custody or has to have been arrested or detained prior to a person to be empowered to cooperate and communicate with a federal official. I think that this is deputizing civilians and giving them a police authority so long as they're an employee of a local unit of government. Is that not a correct interpretation of the plain language in the substitute?
Respectfully, I don't think that's a correct interpretation of the language.
Well, if you want to tighten up the language to make sure that your intent isn't broadly interpreted to give that policing authority, then there should be another substitute forthcoming, because that's exactly what the language of this substitute does.
And then you would support it?
No, I wouldn't. Because this is morally wrong, but now you're technically wrong as well.